Analysis of court cases relating to the Indian Maternity Benefits Act post-2017 amendments. Sanghita Som, student intern. Forward. In an earlier report, we examined the major need for the 1961 Act to be amended in the light of various landmark court cases, India's strong focus on ease of doing business since 2014, and the urgent need to retain women in the workforce, especially in India's burgeoning IT and IT sector. In this follow-up study, we examine whether the nature of court cases underwent any change post the 2017 Megabytes Amendment, which significantly extended maternity leave and introduced new workplace provisions for mothers. In this presentation, we will look at 8 cases related to the 2017 amendment. Table of contents. Benefits for underrepresented categories of women. Shalini Damani vs State of Himachal Pradesh and Organization. 2023, SMT. Chinta Keshwani vs State of Rajasthan. 2023, Denial of benefits based on employment status. Municipal Corporation of Delhi vs Female Workers. 2017, Tanuja Toliya vs State of Uttarakhand. 2020, Dr. Kavita Yadav vs the Secretary, Ministry of Health and Family Welfare Department and Organization. 2023, Delhi State Legal Services Authority, DSLSA, v. Shadeb. 2024, Denial of benefits based on employment status. SMT. Anupam Yadav vs State of Uttar Pradesh and Organization. 2022, SMT. Sonali Sharma vs State of Uttar Pradesh through Prin. Sisi. Det. 2023, Case 1, Shalini Damani vs State of Himachal Pradesh and Organization. 2023, Supreme Court of India. Nature of petition. Additional maternity leave from her employer because her child required more support than she was able to give with her allotted leave. Court order. The Supreme Court directed the Himachal Pradesh government to review its policies for mothers with sick or disabled children, and mandated them to provide an extended leave of 2 years to the petitioner, sealing it as a constitutional mandate. Case 2, SMT. Chinta Keshwani vs State of Rajasthan. 2023, Rajasthan High Court. Nature of petition. In this case, the petitioner, who became a mother by surrogacy, was denied maternity leave because she did not conceive her child. Court order. The Rajasthan High Court ruled that there should be no distinction between natural, surrogate and adoptive mothers, and therefore surrogate mothers deserve the same benefits as natural and adoptive mothers do. Case 3, Municipal Corporation of Delhi vs Female Workers. 2017, Supreme Court of India. Nature of petition. Municipal Corporation of Delhi for many years were denied maternity benefits because they were classified as temporary employees. Court order. The Supreme Court of India struck down this practice, and declared that maternity benefits are to be available for all women, regardless of employment status. Case 4, Tanuja Toliya vs State of Uttarakhand. 2020, Uttarakhand High Court. Nature of petition. In this case, the petitioner, who was employed on a contractual basis, went to court after being denied maternity benefits. Court order. The Uttarakhand High Court validated that women cannot be denied maternity leave based on the structure of their employment. Case 5, Dr. Kavita Yadav vs the Secretary, Ministry of Health and Family Welfare Department and Organization. 2023, Supreme Court of India. Nature of petition. In this case, the petitioner, Kavita Yadav, made an appeal against the 2019 Delhi High Court decision denying full maternity benefits to her, as she was a fixed-term employee, beyond the expiration of her contract. Court order. The Supreme Court of India overruled the Delhi High Court's decision, holding that fixed-term employees are entitled to full maternity benefits under the Maternity Benefit Act, 1961, even after their contractual term has ended. Case 6, Delhi State Legal Services Authority, DSLSA, vs Shadeb. 2024, Delhi High Court. Nature of petition. In this case, DSLSA made an appeal against a ruling that granted maternity benefits to Shadeb, a female advocate, despite her being a consultant rather than a traditional full-time employee. Court order. The Delhi High Court ruled that Anway Shadeb, as a professional consultant and not an employee, is not entitled to maternity benefits under the Maternity Benefit Act, 1961. This overturned the earlier decision that had granted her these benefits. Case 7, SMT. Anupam Yadav vs. State of Uttar Pradesh and Organization, 2022, Allahabad High Court. Nature of petition. Request of maternity leave, based on the Uttar Pradesh Financial Handbook, requiring a 2-year gap between granted maternity leaves. Court order. The Allahabad High Court ruled that since the original 1961 Maternity Benefits Act did not include such a rule, and the provisions of the UP Financial Act only apply in cases of inconsistency, the petitioner was rightfully entitled to her second maternity leave. Case 8, SMT. Sonarli Sharma vs. State of Uttar Pradesh through Prin. Sisi. Det. 2023, Allahabad High Court. Nature of petition. Request of maternity leave, based on the Uttar Pradesh Financial Handbook, requiring a 2-year gap between granted maternity leaves. Court order. The Allahabad High Court struck this down and ruled that, as in the case of SMT, Anupam Yadav vs. State of Uttar Pradesh and Organization, the 1961 Act overruled the Uttar Pradesh Financial Handbook. Conclusion. Following the 2017 amendment, notable trends have emerged in the maternity benefit scene, including extended leave for mothers of disabled children, no time limit for the second child during maternity leave, and contract extensions for women who conceive during the contractual period. These cases highlight the challenges of implementing labor reforms and the court system's role in this process. They underscore the importance of maternity leave, which is crucial for society. As women's rights and maternity benefits gain global significance, these cases may inspire changes, shape future amendments in India, and influence policies worldwide. The final part of this series examines feedback from employers, employees, and labor officers on the amendment's impact and court cases on compliance. Any question, ask C-Quel.